Okay, so welcome to this recording. This is a podcast recording entitled Exceptions to Indefeasibility. In this podcast, I'll probably take about 30 minutes explaining some of the conceptual issues behind the exceptions to indefeasibility and how they operate, and a couple of basic examples. I'm not going to go through all the facts of the different cases because I think it's pretty much a waste of your time, simply because you can read these facts and you've probably got your own notes anyway. So what I suggest you do is listen on the conceptual issues, and for the particular exceptions to indefeasibility, you put a heading in your notes. You put the key cases, of which there are probably between 4 and 7 for each area. Put the section of the legislation, and then put some examples from the facts, because what you're going to need in these cases are, in questions in the exam, are things where you can pull from the facts from particular cases and say, look, this factual circumstance is similar to this one. Right, so let's get started. So here's the coverage of this podcast. I'm going to talk very briefly about the concept of indefeasibility, which we know is the central plank of the torrent system. That is the thing in which the whole torrent system is built around. This idea that once you get registered under the system, that you've got title which is indefeasible or unable to be attacked, or subjected to some form of downgrade in any way. Then we're going to talk about where the exceptions are found in the legislation. I'll give you a bit of insight into what I think are the main exceptions you need to know about, both for this course and in practice. And then we'll talk about how the exceptions operate. And then finally, I know most of you are concerned about your assessment, and for good reason. So we're going to talk about ways of approaching these exception to indefeasibility questions in an exam. So recall from previous podcasts that the Land Title Act sets up a system of registration of interests in land. So that can be the owner of the freehold, and we're really talking about the freehold land register under the Land Title Act. So we're talking about freehold land. That can be the owner of the fee simple, the registered proprietor of the fee simple, or it could be other people or companies that have an interest in that estate, such as a registered mortgage, a registered lease, a registered easement. So the concept of indefeasibility is the plank of this system. It's the hallmark of it. It is the way in which the whole system operates. Now, I'm not going to go into it in too much depth because we've done it in a previous podcast, but you should by now understand that indefeasibility essentially means that once your interest is registered on the title, that is, you've filled out the appropriate form or instrument, as we've talked about in the previous podcast, and that instrument has been lodged and accepted by the registry for registration, then it will be recorded on the details against that lot, and then at that point, that person who holds that interest is only subject to other registered interests on that title. Therefore, if you're unregistered, you've essentially got an equitable or shaky protection, right? So it can be recognised in equity, even if you haven't registered, for example, a mortgage. Equity may recognise as an interest at law in real property. However, the Land Title Act and the operation of the Land Title Act means that it won't be registered, it won't be recognised as a legal interest until it has been registered. Section 184 is where we find that provision. Note there section 184.2, which says that even the registered proprietor, that is the owner or anybody else who's got a registered interest in that lot, they're not going to be affected by any notice that someone else might have an unregistered interest. So if I come along to you and I say, but wait, I've got an unregistered lease, and you say, well, I'm about to sell the property, I don't care. I'm not going to be bound by what you tell me. In other words, I'm not going to be bound by actual notice or constructive notice. That is something we should construct from the circumstances of our discussions. However, there is one thing which we need to know about this, and that is if I take on your interest, so if I say, yes, I see that you've got an unregistered interest, and I am happy to take my interest subject to your interest, then that can create what is known as circumstances for the in personam exception to apply. So this is this case of Barr and Nicolai, which we'll talk about in a second. I'll give you some examples of how the exceptions operate. Okay, so in this basic example, let's look at a basic example of how the torrent system operates. If Amy is the registered proprietor of the fee simple, that is, she owns the fee simple interest, she can alienate it. And remember, we talked about one of the inherent rights that you have in property is the ability to alienate it. So that, remember that there's that restriction that if you stop someone from alienating their interest in land, then it's going to be void as against public policy. That document or that instrument or that arrangement that you've got is going to be void. We looked at that in the context of co-ownership in the case of Paul and Bust. Anyway, so let's assume Amy becomes the registered proprietor of the fee simple interest. What she does next is she sells it to Ted, or she could gift it to Ted, or Ted could well be her son or her partner. So under a will, or could even be her friend, under a will, she could bequeath her interest in the estate to Ted as well. At that point in time, as soon as the document is lodged for registration, Ted becomes the registered proprietor and under section 184 gets the benefits of indefeasibility, such that Amy no longer has an interest in the estate. So that's quite clear. That transfer of ownership has actually occurred. Then what happens is if Ted sells to Steve, Steve becomes the registered proprietor of the fee simple and Ted loses his interest in the estate. Now you can see the system of registration flowing from one party to the next. Now let's take a further example. So if we had Amy again, and she's the registered proprietor of an interest in estate, and Ted happens to be fraudulent, right? He happens to be the hamburger, and he decides, because he's a dishonest person, that he's going to dupe Amy out of her interest somehow. Either through some sort of conduct, he acts dishonestly, for example, impersonating somebody else, or fraudulently signing a document, or taking advantage of Amy if she was in a situation where she couldn't sign documents or didn't understand them, or any of those type of situations. What the system of the torrent system would say, as soon as Ted becomes registered, he gets the benefits of indefeasibility. That's the way that section 184 operates. Section 182 says that the legal interest will pass as soon as that document is registered. Right? So as soon as that transfer document in this case, which is that Form 1, the Form 1 transfer document, which I've shown you in a previous podcast, as soon as that becomes registered in Ted's favour, all the registry cares about is that Ted was on there. They don't look at the circumstances in which Ted obtained his interest. Therefore, prima facie, Amy loses her interest altogether, even though she's been fraudulently removed from her interest has been fraudulently removed. Such then, if Ted then sells the property to Steve, or gifts it, or otherwise alienates it to Steve, Steve can become the registered proprietor and Ted loses his interest in the estate. Now, at that point, let me go back one animation. At that point, Amy has no interest, Ted has become the registered proprietor, albeit through fraud. So the harshness of the indefeasibility provision would say, essentially, that Amy has no interest anymore, and as soon as it goes to Steve, that is one step removed from Amy, there is no way of her getting the property back. Assuming, of course, that Steve wasn't a party to the fraud by Ted. If Steve is just sitting on his own and is what we call a bona fide purchaser for value without notice, that is bona fide, in good faith, he's paid good money for it, and he hasn't had any notice. Not that notice would make any difference anyway, because as we saw under section 184, subsection 2, notice of an unregistered interest doesn't make any difference. Anyway, let's move on. But you get the point that Amy can sell to Ted, or Ted can obtain his interest fraudulently, and as soon as it... So the law, in its wisdom, has recognised some of the ways in which the torrent system could operate in a harsh way. So in the previous example, we saw that if Amy was defrauded out of her interest by Ted, and Ted quickly sold it to Steve, as soon as Steve became the registered proprietor, Amy would lose her interest. She would essentially lose the property. So the law says, well, okay, we need to create a situation where if that happens, we need to allow Amy, or the person who's been defrauded out of their interests, an opportunity to seek redress against the harshness of the indefeasibility provisions. So we have a series of exceptions which have been carved out into the legislation. Some of these, for example, fraud, have several or over a dozen key cases that sit behind them because the concept of fraud is not defined in the Land Title Act, so that we need to then go into the cases. Same with the in personam exception. So that is the one on the top right-hand side, in personam, or the equity exception, which we'll talk about in a moment. Then there's the interest of a short lease. A short lease is essentially a lease which is less than 3 years. And then we've got a situation where we've got a careless mortgagee. So these aren't the only exceptions, but the careless mortgagee, which I'll go into in very briefly, is a situation where a bank or a lender doesn't do enough checks of a person to find out whether they're the person who's obtaining the interest, but nonetheless gets the mortgage and registers the mortgage. That can create problems for the person who owns the property. So we'll talk about that example in a second. But these are the main examples that you really need These are the main exceptions that you really need to be across for this unit. There is another one called the omitted or misdescribed easement, which we'll talk about in a moment. Now, the textbook goes into a lot of detail about all the different exceptions. I don't think personally you need to have an in-depth knowledge of all of them, but you do need to know very carefully these ones and probably this misdescribed omitted easement exception as well. So where do we find these exceptions in the legislation? Well, they're found in two sections. Section 184, which is our key section that talks about the benefits of indefeasibility. You can see there the quality of registered interest has three main provisions. The first is the key one that talks about indefeasibility, that if you become registered, you're only subject to other registered interests. The second section deals with notice and says, and even if you get notice, your interest is still good. In other words, it is protecting those people who obtain an interest, even though they might have heard of through the grapevine an interest of an unregistered interest of another person. And then the third section is carving out the exceptions to the general rule, that is to the benefits of indefeasibility set out in section 1. So they are A, to an interest mentioned in section 185, so we'll talk about 185 in the next slide, or to fraud. So the fraud exception, you can see, sits in section 184 3B of the Land Title Act. If there has been fraud by the registered proprietor, whether or not there's been fraud through an agent. Okay, so essentially that's the fraud exception, that's where it sits in the legislation, and then there's a bunch of cases that sit in behind that. And the other exceptions are found in section 185. So just to recap, the exceptions are found in both section 185 and 184 3B is the fraud exception. Don't ask me why they didn't put the fraud exception in section 185. It probably would have made more sense, but it might have been because of the fact that there's a lot of cases historically from fraud, and that they felt the need to highlight in that particular provision, or there's a difference between the fact that the person never actually obtained, academically, right, we're talking theoretically, that person never actually obtained a good interest at all because of the fact that they had been fraudulent in obtaining that interest or dishonest in some way. In any event, you don't need to know that. You just need to know that there are two separate places in the legislation where we find these exceptions. One is in 184.3b and the other is in 185. So let's look at 185 then. So 185 talks about exceptions to 184. So a registered proprietor of a lot, now that includes the owner of the fee simple, but relevantly for you, it could also include, for example, the registered proprietor of of an interest in that lot. So, for example, the mortgage holder or the leaseholder or somebody who holds an easement, right? So for those people, we could also read this exception as applying. So it's not just the person who's owning a lot, in other words. The first three are probably the most important that you need to know about there. So subsection 1A, B, and C. 1A is the in personam exception, 1B is the short lease exception, and 1C is the misdescribed easement exception. But it's also come down the page, you'll see subsection 1, capital A, that's the careless mortgagee exception. So there are essentially 4 exceptions on that page that you need to be aware of. Although the other ones come up in practice from time to time, but for the purposes of this course, we'll really be focusing on 1A, B, C, and 1A, A and B, 185, and of course section 184.3b, which is the fraud exception. So let's talk fraud. So you recall that fraud was found in section 184.3b. Now this is a case where, well, I've helpfully put this slide up for you, which is a paragraph from an article that was written about fraud, which basically summarizes for you the types of circumstances in which fraud can arise. It is less relevant today than it used to be, because people are less likely to, well, I suppose in one sense it's less likely to forge people's signatures, but we could have fraud happening through, for example, cyber activities or online activities. So it could rear its head again. But just in recent years, we've kind of seen it drop off, at least from, say, the 1990s anyway, 1980s and 1990s. There are 5 different types of fraud. One, where a registered proprietor falsely attested a signature, right? So that's dishonesty, that's fraud. There's another situation where they altered an instrument, whether through forgery or not, so they changed it after it had been executed. So when we're talking about instrument, we're talking about those documents, right? Those Land Title Act forms, essentially, that both parties are filling out. So when you're filling out a form, of course there's some opportunity for someone to act dishonestly. And what they're trying to do is protect their interest, right? So they might be trying to get the actual property for themselves or get an interest on the registry, which they otherwise wouldn't be entitled to have. And they do it through some form of dishonest conduct. And there's 3 other situations set out there. I'm not going to read them out to you, because you can just pause the video and read them. So there's probably 6 or 7 cases. I've put 5 up here for you that you should be aware of the facts in your notes. I'm not going to go through each of these cases. Each has involved fraud in some way. That main case is probably Assets Co. and New Royalty, which is the 3rd one I've listed there. So I would encourage you to have a short, for each of these cases, I suggest you have a short synopsis of the facts, and then what was found, and then that way when you get closer to the exam, you'll be able to say, look, this case is very similar to this situation, or I can distinguish this one from this one. Most of those cases are building on each other, so that they say something along the lines of, well, fraud is more than just a mistake by the registered proprietor. It's some sort of form of conduct which is actually dishonest. Other wording which has been used is moral turpitude, actual dishonesty, actual fraud. It's a very high, there's a standard essentially to get over. Right? So you're thinking of situations where the registered proprietor has been impersonating somebody or forging some document. Importantly, it needs to be the actions of the registered proprietor. So what I mean by this is it can't just be a situation where there's fraud by somebody, because the section says very specifically an interest will lose the benefits of indefeasibility if there has been fraud by the registered proprietor or their agent. So when it says that agent, it might be I tell my friend to fraudulently impersonate somebody in order for me to get an interest in the estate. If that's the case, then he and I have been fraudulent, or she and I have been fraudulent, and my interest will be made defeasible because of the fraud that I've obtained my interest. Right, so I encourage you to have a heading for each of those cases in your notes, and see. And there are a couple of others out there as well, which are also important, but for me, those are the main ones. This is what I was talking about on the previous slide, about the general tests for fraud. You could probably say something along the lines of when you're going through your exam question and you're saying, well, what's the issue here? It's potentially fraud. What's the law here? Well, the law says that fraud is moral turpitude, it's dishonesty, it's impersonations, it includes forgeries, it must be actual fraud, etc., etc. And if you go back into your text, in some of the notes, you'll find that this idea of actual fraud and moral turpitude has been accepted in several of the cases. For example, Young and Hogan in 2001, ANZ and Grigich in 1994, which is a case where you had basically a son moving off his father and fraudulently obtaining interest in the property. Right, so in such a question, for example, if it was an issue of fraud by the registered proprietor, you'd say, fraud is an exception to indefeasibility, section 184(3)(b). Fraud is not defined in the Land Title Act, therefore we need to look at some cases, and then you bring up the cases which are most relevant to your factual scenario. Okay, this is the problem section, the in personam or the equity exception. Now, the reason why I say it's a problem is because it's quite poorly defined in the legislation. It just says under section 185(1)(a), and equity arising out of the actions of the registered proprietor. So in this case, we're not necessarily talking about fraud. We're not talking about moral turpitude or actual dishonesty or impersonating someone or forging documents. What we're talking about is this broad concept that would be unconscionable or otherwise inequitable or unfair for a person to obtain an interest and then turn around and say, but I no longer respect, and because of the benefits of 184, I no longer respect these unregistered interests. Now, the reason why I say it's a problem is because that is a very broad set of circumstances that can arise with the in personam exception. Whereas fraud is a relatively high standard and a narrow set of circumstances, in personam can be anything, equitable or legal, any course of action that could take place against the registered proprietor who's obtained their interest. So, a couple of good cases for this to look at are Barr and Nicolai, Valburn and Powerprop, and Farrer Constructions and Sadie. So those three, if you understand the factual situations of those three, there are a couple more in your textbook. The quintessential one is really this Barr and Nicolai case. It's quite a relatively straightforward set of facts for you to follow, where you had a case of somebody becoming the registered proprietor of an interest in land, saying that they would take their interest subject to these unregistered interests, right? And now, stopping there, that's a big difference between mere notice, right? Me telling you that I've got an unregistered interest that you need to protect, and you actually saying, you being the new registered proprietor, for example, I will take your interest. I realise that you've got an unregistered interest, and I am going to go the extra level and actually agree to take your interest on when I become the registered proprietor. So I'm just going to stop there and let that sink in, because I think that's important to understand that is conduct where one person who has become the registered proprietor, and remember we're talking about the interests of the registered proprietor and the activities that they've done, because it's an equity arising out of the actions of the registered proprietor. They have taken on an interest which is unregistered and agreed to be bound by it. So in the case of Barr and Nicolai, they said, look, that is broad enough for the impersonal exception to apply, because for them to then turn around once they become the registered proprietor and ignore that unregistered interest means that they are essentially acted unconscionably, or would otherwise have had a claim made against them in equity. Right? There's concept of fairness, because they've reneged on a bargain which they said they were going to pursue. So I hope people can see that operation of that impersonal exception. It does fit a very broad set of circumstances, and it's by no means defined adequately in the, well, certainly not defined in the legislation in the Land Title Act, but it's less well defined in the case law as well, because now we have a whole bunch of circumstances which can give rise to the operation of that exception. I would say that the tip to investigating this circumstance is that normally you'd look at factual scenarios and fraud and impersonum come up at the same time. In other words, you'd say your issue that you'd set back for the examiner would be, does fraud arise here? Has the registered proprietor been fraudulent in obtaining their interest? Question mark. If they haven't, have they nevertheless fallen foul of section 185(1)(a), that is the in personam exception? Because those two sections are looking at the conduct of the registered proprietor. Fraud is a very high standard, moral turpitude, dishonesty, forgeries, impersonations. And equity is something which they have done, they've agreed to do, or some other form of action or activity in which it would be unconscionable for them to merely fall back on the benefits in section 184 and ignore all the unregistered interests. So that's why I say those sections are usually looked at together, and if fraud fails, possibly the in personam exception can get up. On the other hand, if fraud gets up, it's also likely that in personam is also likely to get up, because we're looking at some sort of inequitable conduct that is most likely also going to be captured as the fraudulent one as well. Right, so that's the way I suggest you look at these cases. These are the key cases around in personam. Talk about the fact that it is really a broad set of circumstances that can apply. Any equitable or legal conduct that arises out of the actions of the registered proprietor will be sufficient to set aside their interests. Right, let's move on. So I've talked about those first two, which are the more complex two exceptions, fraud and in personam. There's another exception called short lease. So this is found in section 185(1)(b) of the Land Title Act. So what this does is relatively simple to follow, more simple anyway than in personam and fraud, is that if you have a unregistered lease on a property, then that unregistered lease, if it's less than 3 years, will be protected if the freehold is sold. So, in our example on the right-hand side, I've got Tony, and Tony has a tenant, and her name is Cheryl. She's got a lease which is less than 3 years. It's unregistered, in the sense that she hasn't included on Tony's title in a formal registered sense. Then Tony sells to Antoine. The question is, can Antoine kick out Cheryl? As soon as Antoine becomes a registered proprietor, if you followed through section 184(1), you would see that he takes only subject to other registered interests. In other words, Cheryl would lose out. She'd be asked to get kicked out of the property the next day. But the law in its wisdom has carved out an exception for those tenants that have a lease, commercial or residential, and in this course we're mainly talking about commercial leases, that are for 3 years or less. I encourage you to look at the part that talks about options to renew and whether they're protected Generally they will be, but not if it extends the original term of the lease beyond 3 years. So if it's a lease for 2 years and an option to renew for 5 years, then the option is not going to be protected. Right, so that's short lease. It's relatively straightforward. Oh, I should also say a short lease doesn't need to be in writing. There is a section of the Property Law Act, section 12.2, which allows for the creation of leases using parallel evidence, that is oral evidence, or in other words, you can create leases orally or evidence on the back of a napkin or something like that, provided it's less than 3 years. It's not advisable to do that, but it is legally okay to do that. Lastly, let's look at this careless mortgagee exception, or second lastly rather. I've still got to go into the misdescribed easement one, which I'll do very quickly. But the careless mortgagee exception applies only really to mortgagees. Now, a lot of students get confused here between mortgagor and mortgagee. I know I do as well. So mortgagor is the person who owns the property and they want to take out a loan. In other words, they want to mortgage their property. So that's what they're called, the mortgagor. The mortgagee is the person or company or organisation in whose favour that mortgage is being granted. So it's the bank, in other words. So this is called the careless mortgagee exception. So this is how it works. If you have Larry, who's the registered proprietor, look at this example on the right-hand side. He's the owner of the fee simple. Then Troy, who doesn't know Larry at all, goes to the bank and says, Jojo Bank, my name is Larry. And Jojo Bank says, hello Larry. And then Troy says, who's posing as Larry, I would like to apply for a loan and here's my property. At this stage, Jojo Bank thinks that Troy is Larry, but in actual fact Troy is Troy. So what happens is he executes a mortgage over the property, over Larry's property, right? And Larry doesn't know anything about it. Jojo Bank checks to see if Troy is the person that he claims. Sorry, Troy is the person that he claims to be. That is, in other words, he's claiming to be Larry. He's acting as the registered proprietor in order to obtain this loan. And then what happens is those documents are signed and they're registered by Jojo Bank. So Jojo Bank becomes a registered mortgagee. Poor old Larry is sitting on his title, right? So the mortgage is sitting on Larry's title. The security for the loan between Troy and Jojo Bank is sitting on Larry's title. So in such a case, 184 would say, well, Jojo Bank has registered interests. They haven't been fraudulent in any way because they weren't a party to the fraud with Troy. They were just taking Troy on face value. Therefore, their interest is indefeasible and subject only to these other exceptions which might apply. Now, in that circumstance, the law has an additional exception called the careless mortgagee exception. So if Jojo Bank doesn't adequately check the identity of the person who's come to them asking for the mortgage, then they will not obtain the benefits of indefeasibility. Essentially, if you look at that section and you follow it through and it takes you to sections 11A and 11B of the Land Title Act, it will talk about this 100-point test, where the bank is going to need to see identification, driver's licenses, passports, things like that, bank statements. Otherwise, it can act rather harshly upon Larry. Essentially, that's creating a form of negligence on behalf of the bank and saying, we created a standard here where we don't want you to be negligent in finding out who's actually obtaining the interest. Right, the last one we're going to look at is this misdescribed easements. This is a situation which isn't as broad as everybody thinks it is when they first read it. It seems to cover a situation, for example, an easement. Sorry, I'll just go back a step. An easement is essentially a right-of-way over somebody's land. So let's just assume in our example on the right-hand side, we've got Stefan, who's the owner of the property. Kathy and Pete might be the neighbours of Stefan. This is a rural property. And they have some form of unregistered agreement that Kathy and Pete can use Stefan's property to drive their car across. Right. If that's the case, and it's been unregistered, it still might be called an easement in terminology, but it's unregistered. So they won't be protected if Stefan then sells the property to Katerina. Now, on first reading of this misdescribed easement provision, you would say, oh, well, that covers that situation, because it says it's been omitted or misdescribed. It's actually not. It's not as broad as that. It doesn't cover situations of documents that protect easements that have never been registered. In other words, it won't protect this situation. The only way to protect an easement these days is through registration. And in fact, you need to actually register it to be created in Queensland. The law is relatively simple, and you'll see that when we get to the discussion on easements later in the course. Section 185(1)(c) is really for things which are historical in nature, where, for example, when they brought Stefan's property onto the So yeah, it basically only protects a situation where you've got the transfer of land from the old system title into the registered system of land, the land title system, land title act system, and they forgot to bring across the easement at that stage. So it only protects these historical mistakes in describing, or they haven't done it properly at the time it's been transferred across. In other words, it's a far narrower set of circumstances than the creation of an easement, which would be off the register and then seeking protection for it. So then we look at the section on unregistered easements. Sorry, if you look at the section of the textbook that talks about this particular exception, have in mind a relatively narrow set of circumstances in which it could potentially apply. Because in past years, students have got that wrong by assuming that the misdescribed easement exception is for that situation on the right-hand side, where you've got an unregistered easement and it's going to protect them in the event that the freehold is sold to somebody else. Right. So really, with the exam, what you need to do is, if you see this as a possible question of an exception, and it could come up even within the concept of a broader question on leases, or a broader question on easements, or a broader question on co-ownership, or anything to do with registration of land, what you really need to do is stop and think about who the parties are. What I do is I draw a diagram, a very basic diagram, just put squares and boxes and talk about who's registered and who isn't. And then I link the key relationships to the land, to that person, right? So you're essentially following where the interests in that land start and stop. Then what happens is your factual scenario will be set against a time frame. So it might say, in 2003, so-and-so purchased land. In 2005, they created an easement. In 2009, the easement was still left unregistered. In 2010, the property sold to somebody else. And then the question will say to you, advise Mr. Smith as to whether he needs to respect the easement. So that's what I'm talking about when I say the music stops. So you're drawing points along a time frame to say, well, who's registered and who's unregistered. And then that'll help you conceptualize, has there been any conduct, or is there another exception or protection for that person who's unregistered, which will allow them to still have their interests protected. Right. So what I mean by that is, you look at a situation where we're talking about Larry and Troy, that is that Larry being that registered proprietor in the previous slide, and Troy being the person who was trying to impersonate Larry to get the mortgage. You'd stop the music at that point where the question asks you to say, advise so-and-so, and say, okay, at what point am I looking at this? Am I looking at it in 2018? If I am, then what will if I did a search on this day, what will the registry actually show? So I think that's a helpful starting point. So draw your diagram and think about the key relationships, who's registered, who isn't, and then also think about the time frame in which this has been occurring. Then in your answer, you follow the general idea of the IRAC process. So the issue first. The issue here is whether Peter has an unregistered interest which is capable of protection, question mark. Then you go relevant law, and you say, you start with the general premise that the registered proprietor takes free of all other interests except for registered interests, section 184, subsection 1 of the Land Title Act. Then you might say, look, actual or constructive notice is irrelevant, section 184.2. And then you'd say, you need to get into a discussion of your exceptions, right, which is where you're going to get the marks for this type of question. Where you'd say, are there any exceptions that apply? And you'd go through them each in turn. Now, obviously, if it's not a lease question, you're not going to be looking at the short lease one. If it's a question around the conduct of the registered proprietor in obtaining their interests, as I said before, you're likely to end up looking at the in personam exception as well as the fraud exception, because they're around the conduct of what they've done. You might start with fraud because it's a higher standard, and then enter the in personam discussion. Then what I suggest you do for the better answers is to grab some of those facts which are talking about the in personam and the fraud exception, bring them in and say, is this similar to Young and Hogarth? Or is it similar to Grigich and ANZ? Or does it pass the high standard of moral turpitude and fraud set out in Farrick instructions in SADE? So that's the way I suggest you approach those cases. The ones that were to do with careless mortgagees, probably more you're talking about the legislation, because it's quite a new section. So you're talking about section 185, 1A, and also 11A and 11B of the Land Title Act. There are less cases on that. And the same with the misdescribed easement and the short lease one. Those ones are really questions of statutory interpretation and your ability to apply it to the facts. Whereas the in personam and the fraud one, a whole bunch of cases that sit behind them that you'd be expected to bring in there. Then at the end, following your IRAC model, you make a conclusion. Therefore, Peter's interest is likely to be defeasible because of the operation of section 185 3B. Okay, so that's the end of the podcast. I have gone longer than I said I was going to go, which you're probably used to me now telling you that I'm only going to go for 30 and then I'll go for 40 minutes. Hopefully I've been able to give you an overview of these exceptions and how they work. I wasn't going to go through any of the cases and the detail and the facts, otherwise it would be an hour and a half lecture. And in actual fact, it's better for you to look at the specific facts scenarios, develop your notes accordingly for each of those exceptions and the headings. As always, if you've got any questions, please just email me. We'll be dealing with these exceptions in the tutorial, and they'll come up through the rest of the course as well. Okay, that's it. Thanks.